And we will start in 3, 2, 1. Welcome, Legal Eagles. Today we're diving into the AI abyss, where algorithms wear suits and chatbots bill by the byte. Buckle up, it's going to be a wild ride. This is the latest in the GLS series of masterclasses, and today we're going to be looking at the interesting topic of AI. Now, whilst that initial introduction was generated entirely by AI, I promise that the remainder of this presentation is entirely organically farmed GLS wisdom. A couple of quick housekeeping notes before we get going. One, you're all invited to introduce questions to the discussion. However, for the sake of the recording, could I please ask you to keep your microphones on mute and submit your questions via the chat function? We will then address those questions at the end of the presentation. Also, to heads up, you are being recorded, and a copy of this recording will be published on the GLS website within 24 hours of completion of the presentation. So, with that, let's get going. Firstly, what are we going to be talking about today? Firstly, we're going to be looking at what AI tools are available for in-house lawyers. We're then going to be looking at the implications of those tools and AI in general for in-house legal teams. We're going to get relatively metaphysical and try and define what exactly we're talking about when we say AI. And then once that is defined, we'll look at some tips, tricks, and guidelines for how best to adopt AI into your business and day-to-day operations in a safe but efficient way. So, first things that to catch the eye with. Now, an early conception of this presentation was in fact just going to be an introduction to the AI-based legal technologies that have been introduced in 2024. But there were, in fact, so many AI tools that have been introduced that simply ceased to become viable. Honestly, it's at the point that there's so many that specifically dedicated to in-house legal teams that the mere act of animating this slide almost broke my PowerPoint presentation. And the tools that are currently being displayed are only the ones that I have personally tried. This gives you a real sense of the explosion of AI tools in the marketplace today. To summarize, there's been a huge number of those tools. Some of them are free, some of them cost very little, and some of them are incredibly expensive. If these tools are of interest to you, and given that you're attending a webinar entirely dedicated to AI for in-house lawyers, I assume that they are of interest to you. We will be sharing these presentation slides after the presentation. Each tool is hyperlinked in the slide so that you can go to it and try it if it is something that catches your eye. In addition, we have created an entire blog dedicated entirely to AI tools for in-house lawyers. So it would strongly encourage you to browse through that blog and these tools at your own leisure and experiment with the ones that you think would be of the greatest benefit to your department. For the purposes of this presentation, however, we'll highlight that AI legal tech that's being currently marketed to in-house teams can be loosely grouped into 4 key categories and themes. These are contract review and due diligence tools. Those are tools that do the thing that most looks like lawyering to the layperson. For example, Legal Sifter is a contract review tool that GLS sells through the Legal Operations Center. The key thing for this tool is that it assists lawyers to review contracts faster and to a higher standard than they would be able to do without any assistance. What these tools do not do, certainly none that I have seen do, they do not replace the lawyer. Rather, these are tools that enable your legal team to do their jobs more efficiently, in the same way that Excel as a spreadsheet enables your auditors to do your accounting better, faster, cheaper. They don't replace the need to have an accountant or an auditor. Now, you may have noticed that across the bottom of the screen are subtitles. These are subtitles in Spanish of what I am saying during this presentation. These are tools that are not directly related to the legal teams, but are of use to help you get your day-to-day things done better, faster, cheaper, or in this case, enable us to spread the word of GLS and legal operations to a wider audience than we may otherwise have been able to do. The second category falls in, and this falls into our second category of tools. These are admin support tools. So this translation service that we've been talking about, or subtitling service, that is now built into Microsoft Office, and we haven't had to pay anything extra for it. It just appeared one day, right? We'll come to that particular issue with a bit more detail throughout the course of this presentation. Second ones that are more directly related to the day-to-day business of an in-house legal team would be something like Bright Flag. Bright Flag is another tool that is available on the GLS Legal Operations Center. And what this is a tool that helps you to review the invoices that you receive from your external legal counsel. The idea of the tool is that it automates and does very quickly and to a high degree of accuracy the reviewing of all of those time entries that make up your legal counsel's bill. The net result is that the average invoice ends up being reduced by 10 to 15% on an undisputed basis. That is, the law firms themselves don't even dispute that the invoice should have been 10 to 15% cheaper, because what the tool is doing is highlighting where time records have been double entered, or where you've been charged for the wrong project, etc., etc., etc. This is a thing that typically took general counsel hours to do every month. And not only is it hugely time intensive, it's an incredibly boring and frustrating part of the job. So having an AI tool do it better than you're able to, faster than you're able to, is a real pleasure to add into your kind of arsenal of tools that are available to help your department operate. The third category is litigation tools. Now, litigation discovery typically involves processing a huge volume of documents and correspondence very quickly as you're building your case or defending your case. So this is an area where AI can be particularly useful because, again, AI is very good at processing huge volumes of information sensibly with making very few mistakes. So also, it's a very easy thing for AI developers to charge for because it's very clear what your traditional cost for doing that work with a human used to be compared to what it costs in terms of time doing it with the tool. Like, it's a very easy one-for-one comparison, and you can see that the AI does it much faster and to a higher standard. Finally, what we call the Trojan horse tools and services. Now, these are in some ways a real blessing in the sense that these are freebie tools that suddenly just appear in your life in the same way that our webinars now have Spanish subtitles. So wonderful, like it's a real point of value that's been given to us without any cost. The other side of that issue is, though, that this is a real risk area when it comes to managing AI and your protocols for AI procurement within your business. So these typically apply in those procurement scenarios where annual renewals happen without review or happen automatically. The classic example being your Microsoft 365 licensing fees just get renewed without anyone thinking and without anyone negotiating with Microsoft, because frankly, you're not going to get anywhere when you do negotiate with Microsoft. But all of a sudden, there's now an AI tool in your company's IT ecosystem. So how are you going to manage the risks that are inherent to any AI system? Okay. The final point to mention on this slide is that many of these AI tools that we're talking about, so Legal Sifter, Bright Flag, etc., 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 these are all available on the GLS Legal Operations Center, and for many of them, it is possible to have a free trial of them to see if they would work within your ecosystem. So if this is something that would be of interest to you, do visit the Legal Operations Center and do reach out to your GLS relationship manager and inquire about a trial for yourself. Okay. So that was a bit of a swift whistle-stop tour through some of the cutting-edge tools in the AI front. Let's now have a look at what these tools mean for in-house lawyers. Firstly, and probably cannot be overemphasized, it certainly isn't something that people are being shy about emphasizing, is that AI represents an opportunity to improve the operational efficiencies within your legal department. They're also a way of adding value to your business and present investment opportunities for that business. AI tools themselves can be used to streamline routine tasks such as contract review, legal research, and document management, which significantly reduces your time and manpower costs and frees up capacity within the department. A key aspect about the AI tools that has quickly come to prominence is that AI appears to be particularly useful when it comes to processing large volumes of data or doing highly repetitive tasks. Exactly the kind of tasks that human beings tend to get bored of doing, and as a result of being bored or having their attention wander, tend to make a lot of mistakes on. So the AI kind of revolution does seem to suggest that there will be a really good way of reducing the human errors that appear in the day-to-day operations of an in-house legal department. Different, slightly underappreciated aspect of AI is that in a multilingual region like APAC, many professionals are operating in their second or third languages. So being able to leverage natural language processing and machine learning has enabled the communication standards of the region to be significantly improved. First drafts are being done by AI, and those drafts are often better than the standards being achieved by kind of a human trainee lawyer that can produce themselves. Never mind a human trainee lawyer who's trying to work in their second language. And secondly, you've got embedded proofreading and translation tools, which further reduce the incidence of errors and typos within your documentation. This has really assisted cross-border deal completion and has reduced incidence of disputes that typically arise from miscommunication. AI also provides a really good way of introducing advanced analytics and predictive insights into the management of your in-house legal department. This means that you're able to anticipate and mitigate legal risks more effectively, enhancing the overall risk management strategies of your business. Finally, increased capacity for strategic work. What we're talking about here is that the AI is effectively doing the time-consuming business as usual tasks that sucks up so much capacity of a legal department day to day. These are all important tasks, so they do have to be done. We can't just ignore those tasks. So AI provides a way of doing those tasks and more efficiently, and thereby freeing up your legal team capacity for higher value strategic activities that more directly contribute to the growth of your business. Basically, what we're saying is that AI is a tool that can greatly assist legal departments achieve that hallowed ground. Now, I'm sure some of you have seen this graphic before, but it is a good one to explain the point. What we're trying to do is get the typical traditional capacity and workload of a legal department from this status, where the vast majority of the time and capacity is dedicated to grind zone, relatively boring, repetitive, business as usual, administrative type tasks, over to this status, where all of those grind zone tasks are being done more efficiently, and thereby freeing up the capacity of your department so that you can dedicate that capacity to kind of breaking new grounds and new jurisdictions, dealing with major events like black swan events, i.e. doing the strategic work that the business has actually employed you to do. This transformation from old law to new law kind of capacity arrangement is in essence exactly what all of the GLS products and services are designed to facilitate. So AI fits very neatly into that approach to legal operations. However, that is AI when it is implemented correctly. And that is a massive qualifier. It can be implemented in a way that achieves these wonderful outcomes, but there are risks, and implementation has to be done correctly. Otherwise, very material costs and inefficiencies can occur. So with that in mind, we want to move over from the light side of the opportunities presented by AI to the risks presented by AI. Now, that tonal shift does risk me appearing to be the party pooper here. But the role of the in-house lawyer must go beyond simply being excited by upside potential. We must be aware of the risks inherent to AI's, well, specific to AI tools and AI implementations. And it will be the in-house legal team that have a material role in mitigating those risks and protecting the business from them. Some of the major risks to start thinking about are, for example, compliance risk with the suite of AI-specific regulations that are currently being released around the world. There has, in fact, been an explosion of AI-focused or AI-adjacent legislation in almost every jurisdiction in the world. This creates a new compliance obligation on the business, and therefore there is a risk of non-compliance. Moreover, there has in fact been so much AI litigation that arguably there's more AI legislation now than there are AI tools to aim it at. So some quick notes on the major bits of legislation that we need to be aware of. The biggest, most recent event in the kind of AI legislation world is the European Union's Artificial Intelligence Act. The way that we would describe this act is that it is a risk-based, complex, multifaceted piece of legislation that builds on existing legislation like GDPR. What the European Union is doing with this act is trying to engender what is termed the Brussels effect. In the same way that GDPR became the global standard for data privacy legislation, well, GDPR got published and became the global standard for data privacy legislation. All other jurisdictions around the world passing variations on data protection legislation, but those variations are aligned with the requirements of GDPR so that those jurisdictions can continue to trade with the European Union, i.e. the world's greatest trading bloc. And a similar approach is hoping to be engendered in relation to AI. So the EU Act, whether it will or not, remains to be seen, but it is certainly positioning itself to be that global standard that all other jurisdictions align with. In the UK, AI legislation has generally taken a different approach to what's set out in the EU AI Act. In the UK, responsibility for AI legislation has generally been devolved to sector-specific regulators on the basis that those regulators are more agile and have practical expertise applicable to the legislation. Now, it is worth mentioning that a overall AI Act has been tabled in the House of Commons in the UK, and it does appear that a new government will be elected in the UK in the very near future. So that current status may change in the near future, but that is certainly the approach has currently been taken in the UK. In the US, it's a similar deal. There's no overarching federal AI legislation. Rather, responsibility for AI-related top issues has been devolved to applicable federal agencies. Confusing that picture, though, is that almost every state within America, all except for Wisconsin for some reason, but particularly California, are passing their own versions of AI-specific related legislation. So there's a huge raft of AI legislation that's coming out of America. And frankly, it's such a wide variety of approaches being taken that itself might cause a risk vector. It might be very easy to effectively have arbitrage between jurisdictions. The final point on legislation is to look at it on an international context. The point here is that all countries seem to be taking a very active role in addressing AI legislation. So there's a lot of bilateral and multilateral collaboration occurring between nations. It seems like everybody's learned the lesson from the development of social media platforms and kind of tech behemoths like Google, and don't want to be caught sleeping as the next big thing occurs. All jurisdictions seem to be actively trying to approach legislation on AI and finding international treaties to reinforce their positions. This includes the Xiamen conference that happened about a month ago, which is direct bilateral relationships between People's Republic of China and the African Union nations. Also, the Seoul Summit that happened 6 weeks ago in Korea, where Australia, Canada, China, France, Germany, India, Indonesia, Israel, Italy, Japan, Kenya, Mexico, Netherlands, Nigeria, New Zealand, the Philippines, Korea itself, Rwanda, Saudi Arabia, Singapore, Spain, Switzerland, Turkey, Ukraine, United Arab Emirates, the UK, United States, and the European Union all passed binding declarations. So, like, this is a live topic that is seems to have really excited the world's legislators. Taking a step back, we can say that the general trend with all of this legislation that is being passed is that there seems to be a desire on behalf of all of those law writers to promote safety and security, responsible innovation and development, equity and unlawful discrimination, or protect against unlawful discrimination, and protection of privacy and civil liberties. This is being balanced by a very enthusiastic effort to ensure that their jurisdictions remain competitive and are promoting AI innovation within the jurisdiction. In preparing for this presentation, I read that no fewer than 15 jurisdictions from France to Australia to Rwanda have all said that they want to be the world center of AI innovation. So it gives a sense of like the tactics being taken when it comes to legislation. Okay, so that's risks arising from AI specific regulation. In addition to that, there remains the general risk of compliance with the existing regulations, for example, GDPR, the California Privacy Rights Act, and the Equality Act, and indeed in Singapore, the Health Products Act. All of these are not ostensibly AI-specific legislation, but they are compliance obligations that might be at risk by the use of AI within your business. So it's something to keep close attention to. Another key risk is intellectual property. This is probably one of the areas where the greatest risk is the divergence of approaches being taken across the world. At this point, it seems that most jurisdictions, or many jurisdictions, are taking very different approaches to intellectual property and the concepts of what defines intellectual property, who can own it, and what role does concepts like fair use have in relation to intellectual property. Because of this lack of clarity of the law and how it's being applied, there is a high risk inherent to this area. This is a dynamic area that is undermining the ability of in-house legal teams to grow business for their companies and to protect their value. It's something that has to be addressed very carefully. Speaking about being careful, probably one of the most famous issues currently being presented by the mass adoption of AI is the risk of information leakage. The specific risks here depend on the nature of the system that you're using or talking about and how it is being implemented. In particular, a key risk that seems to have appeared or seems to have materialized is the contractual relationship with the provider of that AI system. A very good example recently being what happened at Samsung. At Samsung's computer chip division, 3 different occasions in 12-month period, 3 different employees, all working diligently in what they thought was the best interests of Samsung, uploaded what turned out to be extremely confidential information to OpenAI's ChatGPT to help them do their task. Specifically, we're looking at testing protocols for computer chips. Now, in this way, incredibly valuable intellectual property suddenly got released to OpenAI. But this is not something that Samsung as a corporation could resolve because Samsung had no contractual relationship with OpenAI. It was just that their employees had accidentally uploaded training data to ChatGPT. And so what Samsung tried to do was that board members of Samsung literally telephoned board members of OpenAI and tried to find a resolution. And they found a bit of a compromise, but the point remains. There's a real risk of data being leaked to suppliers that your business has no ostensible relationship with. This kind of goes to a greater point that a problem with AI at the moment is that it's very new technology that is not fully understood by users of that technology or even the developers of that technology. So part of the risk factors that need to be addressed by in-house lawyers is the fact that mistakes are going to be, mistakes are almost inevitably going to happen. So it's not good enough to just say, don't do X. You need to be thinking about how to mitigate an issue that has occurred or how to respond to an issue that has occurred when you don't know what that issue is going to be ahead of time. Okay. A few more quick risks and we'll canter through. With AI systems, implementation carries with it an integration risk. Like, can that AI system integrate into your existing IT ecosystem? One question. Second question is, if it does integrate into your existing systems, does that have an impact on kind of volume-based metrics and pricing that's inherent to your traditional systems? So a good example would be do things like accessing to data or trading numbers start getting influenced by your AI system. I guess the case to look at would be SAP versus Diego that occurred in the UK High Court in 2017. In that case, whilst it's not directly an AI case, a similar issue has occurred. SAP wanted paying for additional license fees when third-party systems accessed the data generated by SAP's system. Integrating AI into your ecosystem runs that exact issue. Is your AI system starting to take data from another supplier's system, and is that affecting what your expected budgeting for those operations is going to be? Probably more of an issue for the IT department by itself, but certainly a risk factor that the legal department needs to be involved in mitigating. Finally, we're talking about the system complexity. We mentioned the sheer complexity of the system is causing problems to itself. AI systems appear to be prone to hallucinations, presenting information as fact, even though that information has just been effectively made up. It's prone to privacy and confidentiality issues, disinformation, toxicity, kind of amplifying embedded biases, and it has obviously major issues for copyright. The problem with the AI systems is that they're so complex that it's very difficult for legal teams at the moment to understand what's going on, and therefore their ability to mitigate those risks is being challenged. In this context, the concept of explainability needs to start becoming a bigger part of your day-to-day operations. When you're engaging with an AI provider or an AI-enabled service, we need to start using explainability statements a lot more often to enable you to assess the risks inherent to what are very complex systems. Getting to the end of these risks. Oops, sorry. Let me reverse that. Getting to the end of some of these risks. As in-house lawyers, we do still have professional legal standards. some of those standards are themselves being challenged by the mass adoption of AI. In particular, you have a professional obligation to supervise non-lawyers involved in your practice. Arguably, and many academics do argue this, that includes supervision of AI systems that you're using in your practice. It is not good enough to just say that the AI system made a mistake. As in-house lawyers, we are and will remain responsible for the failings of any AI system we use. The flip side to that is that it's not okay just to say, you know what, I can't trust the AI system. I'm just going to ignore it and not use it as part of my day-to-day operations. As lawyers, you do have a professional obligation to stay up to date with available technologies, particularly where that technology can make your services better, faster, and cheaper. So arguably, we're all professionally obliged to become competent users of AI tools and systems that are available to us. Okay, moving on to governance. Many of the risks I've identified above are risks that arise from specific implementations of specific AI tools. On top of that, we need to start thinking about AI governance as a whole. What I mean by that is that the best companies are not just thinking about mitigating risks from specific applications. Rather, they're thinking strategically about what does it mean for a business to be adopting many, many forms of AI simultaneously? Like, is that itself a strategic risk? Or more importantly, how can that be approached strategically to maximize the profitability of the business and manage the risks inherent in so many different systems being adopted simultaneously? Last point in terms of governance, and I've put this here mainly because it doesn't fit very well anywhere else, and mainly because it seems to me to be an issue that's being massively overlooked in the marketplace right now, is that AI does have a massive environmental impact. The AI revolution doesn't come for free. For example, adding generative AI to Google searches has increased the energy consumption of those searches by a factor of 10, to the extent that AI-based Google searches last year alone in 2021, equated to the entire carbon footprint of the country of Ireland. So there are real environmental impacts of the mass adoption of AI. And if this is something that's important to your business and your engagement with the world, it needs to be considered carefully. Okay. What exactly is AI? Like, what are we talking about here? If we're going to start protecting our businesses from these risks inherent to AI, we need to be able to include sensible contractual provisions and adopt appropriate policies. If we're going to do that, we need to be able to define what exactly AI is. Unfortunately, there is not currently any universal definition of what artificial intelligence means. In the absence of a kind of global standard, we have come across some attempted definitions that have tried to approach the question from a very simple approach. In this case, artificial intelligence means any system that uses or is based on artificial intelligence. This was like a real example from a real contract that GLS ended up marking up. Now, basically, this is so simple that it doesn't work, and it's kind of self-referential and is a terrible piece of drafting. Like this quote applies. But I can see where the lawyer who drafted this was coming from. Basically, they were taking the approach taken by the US Supreme Court in GLS versus Ohio. You'll know hardcore pornography when you see it. This person's thinking, what I'll just say is, we all know what artificial intelligence is. We'll know it when we see it. However, taking this approach is probably too vague to be useful, and certainly it's open to challenge, which itself is unreasonably expensive to resolve. So maybe a better approach would be to copy a definition from some of that major legislation that we're talking about. Well, there have been a lot of efforts by our esteemed lawgivers to provide good definitions of what constitutes artificial intelligence. And some of them have been fairly reasonable. But as always, there is an issue when law writers are trying to grapple with cutting-edge technology that they are not experts in. This example is from the National Security and Investment Act of the UK from 2021. For me, this definition highlights one of the typical issues that's coming up in some of the legislation in this space. It's falling into the trap of blurring the line between a machine's statistical processes and human perception and cognition. For a working definition, we need to avoid getting into metaphysical debates about what exactly defines intelligence or thinking. This is a rabbit hole that will go on forever, and you'll get trapped in if you dip your toes into it. So legislation like the National Security Act has a real problem that it inherently implies that the system has some kind of human cognition or thinking. What our recommendation to you today is that you can make things a lot easier for yourselves by remembering that the purpose of this definition is not to unveil some kind of philosophical essence. Rather, we're using this definition as a real tool to help us manage the risks of AI implementation within our businesses. So, with that in mind, the evolution of the European Union's Artificial Intelligence Act and its definition can be quite helpful. The earlier version of this definition avoided that metaphysical question, but it did have some issues of its own. Firstly, it referred to a specific schedule of approaches. This made the definition susceptible to becoming overtaken or made redundant by developments in the technology. For example, the intelligent machine approach of the second generation AI systems incorporated fixed programming rules and assumptions, which is very different from the large language models that are in vogue today. So there's a real risk that your definition will not keep pace with the development of the technology. Also, this definition foregrounded the issue of inputs, and you'll see this in a lot of legislation around the world at the moment. We're talking about human-defined objectives and inputs made by a person. The problem with this is that it unnecessarily introduces instability to the definition, as it's fairly unclear what a human-defined objective is. Moreover, it's questionable whether human inputs are necessarily required for many AI systems at all. And thirdly, a definition of a system is not typically need a definition of the person that's using that system. So, moving on to what became the definition of the final act that got passed by the European Parliament, we can see that the references to Annex 1 techniques were removed. There was also a lot of debate about that question of inputs, and in the end, the references to inputs remained. Nonetheless, we're now getting to approaching something that can be kind of useful for our purposes. It's removed some of the ambiguity of those earlier drafts, and there's a light at the end of the tunnel. We can see potentially a way to a resolution. For me, I particularly like the definition created by Chris Easton, who's a partner in the technology department within Field Fisher. His definition really tries to, well, firstly, it borrows heavily from the UK and EU legislation, but it avoids those metaphysical traps. It avoids some of the ambiguities of those definitions by sidestepping the issue of influencing or inputs. And we don't even need to get into the debate about who input what or what the outcome was. And finally, it includes a future proofing, i.e., other approaches designed to approximate cognitive value. This definition is something that we could confidently implement into our clause banks and templates today and be fairly confident that it will still work in 10 years' time. For me, though, I would respectfully suggest that his definition does still have a minor vulnerability. For me, I think that anything that relies on establishing the intention is opening a potentially very expensive can of worms, as it inevitably costs a fortune in legal fees to ever establish what another human being was thinking at a particular point in time. So for GLS, we would use Chris's approach to avoid references to inputs and implied perception and the ambiguity of that original EU Act. We'd also, for use this technique to kind of future-proof the definition for our future use. But we would just simply sidestep the issue of intention entirely and use a definition that is solely reliant upon objectively verifiable fact. Is this a system that uses any of these things and generates any of these kind of outcomes? So now that we have a definition of AI, what other things can an in-house legal team be doing with that definition to facilitate implementations of AI into their business whilst mitigating the risks of those implementations? One point to note is that in this section, I'm assuming that you're a business that is not looking to purchase AI products. Is looking to purchase AI products, but you're not a provider or developer of an AI system, as you, in that case, would have regulatory and compliance and explainability obligations that are quite distinct. So, like most risks in a commercial business, primarily we're going to address those risks by the use of our definition in the updating of our procurement contracts. When we're doing this, however, it's helpful to clarify two categories of procured artificial intelligence, as these will define the applicable risks and responses to those risks. Firstly, we have AI as a service. Your business is actually trying to procure an AI system, and it is the system itself that is the key deliverable of your procurement. The second scenario is when you're buying an AI enhanced service. So this means that you're procuring a normal service, or what traditionally would have been a normal service, but now has a service provider that may in some ways utilize artificial intelligence to perform that service. In the first scenario, what we're looking at to address, or what you'll need to address in your contracts, are regulatory considerations, data set controls, IP protections, acceptable use policies, capability statements, and cyber risk management obligations. On that final point, what we're talking about here is that suppliers will be looking to retain rights to suspend your access to the AI system, whilst also imposing obligations on you as a customer to ensure that the systems are protected from your integrated systems. this can become incredibly expensive. So if this is something that's going to be an issue to you, do give us a call and we'll talk you through the issues here, because the costs of protecting AI systems from bad actors is unbelievable. Okay. And sorry, at this point, I'm running at pace, so I'm a bit conscious of running out of time on this presentation. When it comes to AI enhanced services, what you're needing to be looking at is, firstly, first issue is that a lot of suppliers are trying to limit their warranties in their supply contracts to the equivalent of the deliverable will match the specification. This does not work in an AI context, not least of all because most lawyers are unable to, or don't have the time, to assess the adequacy of an AI system specification or the language that's being used to describe how that system will integrate into the supplier's services. Rather, the approach you want to be taking in this scenario is insisting that supplier gives specific warranties or commitments to outcomes, not specifications. Now, this has been best practice for service agreements for many years, but is particularly acute given the complexities of AI integrated deliverables. You want it to be clear that the supplier bears the risk of AI failing, and there must be a sensible remedial mechanism in your contracts to compensate you as a customer in the event of an AI failure. Obviously, data privacy is an issue, but how exactly is an issue? For one thing, there's a real risk that the introduction of AI into a service provision changes the relationship between which party is the controller and which is the processor. Recent legislation and guidance in the UK strongly suggests that the supplier will become the controller as they are defining the algorithms of their AI systems, which is very controlly behavior. So you need to be alert to data privacy issues whenever AI starts being involved in service provision. Moreover, there's a real value to data ownership now that didn't traditionally exist. Is your supplier able to use your business's information to train their systems? This is a concept that gets snuck in a lot into service contracts. And if it's an issue to you, you need to start thinking about, do we restrict the supplier's use of that information entirely? Or do we insist that if the system is going to be improved by our information, that there should be some kind of fee reduction or profit sharing mechanism in place to allow us to benefit from that improved AI system? Finally, if you are going to remember one thing from today's presentation, I would strongly recommend that you at least update your procurement templates to include an explicit obligation on your suppliers to be transparent and notify you if they intend to use AI at all. This obligation should include an obligation on them to provide you with enough information that you can reasonably expect it to assess the security and appropriateness of the AI that they're intending to use. No matter what your service and goods contracts currently say, this is something that should be introduced to them to help to protect you. Okay. We've got 30 seconds to run through the final to-do list of an in-house legal team when it comes to AI implementations. Firstly, whilst our contracts are obviously a key shield for the in-house legal department when it comes to defending your business from AI risks, it's not the only defensive tool available to you. You also have policies. You should be looking to implement clear policies on AI use and procurement within your business. The ISACA, which is an IT security association that's well respected around the world, did a survey in 2023 and found that only 10% of companies currently have any kind of formal AI policy in place at all. That's despite the fact that 40% of their employees reported that they were regularly using AI. Now, the opposite issue is you can't just approach this problem by creating a policy that says you as an employee of this company should not use AI. A number of banks have done this, but it's a terrible idea because frankly, everybody within the business just ignores it. So what you're doing is you're creating you're creating a problem for yourself and blindly ignoring what is quickly going to overcome, which is quickly going to result in a tangible risk, not least of all that you're effectively hampering the ability of your employees to become skilled in a thing that will generate profit for the business. As mentioned earlier, the best companies have AI policies that extend to AI governance. They're thinking strategically about how many forms of AI can be quickly incorporated into their operations simultaneously, whilst serving an overall strategic vision. Moreover, if AI is a product that you are selling, or is a product that is going to be involved in the services that you are selling, you need to consider how to ensure that your services are now safe by design and have appropriate explainability statements for your customers so that you can be transparent about your operations. Contractual protections are wonderful, but they're not going to stop the harm that your business will experience and from reputational loss and loss of potential business if the public thinks that what you're doing is the wrong thing, or you lose face in the company, in the public's eye. Note that in Singapore, you can freely access the Model AI Governance Framework, which comes with implementation guidelines and a compendium of use cases. So you really have no excuse to be failing on this front. Quick, easy wins for you to do is to update your clause bank to include appropriate AI provisions. These don't take long, and if you need any support on this side, you can ask GLS. AI versus M&A due diligence is a massive topic that was going to be incorporated into this presentation, but we're already over time. So what we're going to do on this particular topic is defer it to a later presentation. But if in the interim you're considering investing into an AI provider or a business whose value is materially influenced by the AI that they're using, please do reach out to GLS and we'll support you directly. Finally, training. That ISACA server that I mentioned found that despite employees quickly moving forward with the use of AI as a technology, only 6% of them had any kind of training for their staff at all. That includes training for teams that are directly involved in AI. This is extremely irresponsible. If your business is not providing such training, you as an in-house lawyer and legal department should at least consider implementing some kind of training for your legal team and encourage the business to roll similar training out across the entire ecosystem. There's two aspects to this. Firstly, your team needs to be conscious of the risks that are specific to AI so that they are better able to help mitigate those risks. Secondly, AI use is not the same as a Google search. How competent you are at prompting an AI system will directly relate to the quality of the output generated by that system. This does take real practice, and it's something that is not, it's not intuitive. You do need to get better at this. This is a skill set to learn, like how to swing a tennis racket correctly. And the world is quickly dividing into the skilled prompters and the kooks. And you definitely do not want to let your legal team be left behind as the kooks. So to wrap this up, there are a lot of tools and opportunities. There's a lot of tools available to in-house lawyers that provide opportunities to greatly improve the efficiency of your department. These tools do, however, come with risks, and those risks can be mitigated, but this will require proactive, conscientious thought from the in-house legal department itself. If you do need any assistance with these, you can ask GLS to help you. We provide a huge number of consultancy support services in this area, including program design, clause bank and template upgrades, readiness evaluations, and negotiation support. So you're not alone on this journey. Feel free to reach out if you want some support. Additionally, you can, as always, go to the GLS Legal Operations Center, where there's a huge variety of free know-how resources and tools for you to use to help improve and how to improve your operations. With that, I would normally pass over to Q&A, but frankly, we're already over time. So I'm just going to say thank you very much. And if you do have any urgent questions, please just email me and we'll follow up offline. Goodbye.